The following program was produced by the United States Courts.
Good afternoon, everybody. It's my pleasure to welcome you all to this symposium to celebrate the 50th anniversary of the Criminal Justice Act today. I was honored to be asked to speak, although it was emphasized to me several times that it should be briefly, by Kate Clark. And having now reviewed the list of distinguished speakers and panelists on the agenda for this afternoon, I'm going to be sure to make my remarks even shorter than usual so that you can get to the interesting part of this program. Anyone that's heard me speak knows that me speaking shortly is a relative term, though. It's really wonderful to have people here from so many different backgrounds and perspectives to celebrate the 50th anniversary of the Criminal Justice Act. I had the privilege of serving as the federal public defender for the Eastern District of Virginia for almost 10 years. And while I have now been a magistrate judge for a very brief time, it has already struck me how critical it is to have skilled, dedicated, and zealous defense counsel in the courtroom in every criminal case. This 50th anniversary serves an important purpose. It gives us the opportunity to reflect on how much has been accomplished since Robert Kennedy first championed this issue, and to focus on what needs to be done to ensure that we have a criminal justice system that is fair for all, regardless of means, moving forward into the future. And although we're recognizing the 50th anniversary of the Criminal Justice Act today, this process of reflection began in earnest almost 2 years ago with the 50th anniversary of Gideon v. Wingright. And you all may remember that that was 2013, which coincidentally also happened to be the year of the sequester here in Washington, D.C. And it's when the Defender Services account in the judiciary, which funds both the Federal Defender Program and the payment of CJA lawyers, was brought to the brink of disaster. Now, I had the privilege of working with many of you here, including Judge Blake and Kate Clark, Ed Bostic, and I'm delighted that they're all on the panels and will be participating today, in an effort that we all engaged in to convince lawmakers and judges and the public that adequate funding for indigent defense was not a luxury, but a constitutional mandate. And during that dark period of time, federal defenders were forced to prepare for possible layoffs of 30% of their staffs. Ultimately, Congress and the judiciary acted to save the program from the most devastating effects of sequestration. But it was not without substantial pain. There were temporary cuts to the CJA hourly rate, which is already lower than it should be to keep up with the cost of doing business. And the Federal Defender Program lost more than 400 positions. The program is rebuilding now, thanks in large measure to the efforts of many of you who are here and are dedicated to the principles of equal justice under the law. And I'm especially grateful to Judge Blake and the Defender Services Committee for their continued commitment to fighting for adequate funding for indigent defense in the federal courts. But this recent crisis underscores the importance of today's symposium. There are challenging and important questions to be asked about the future of federal indigent defense, and we must think critically about ways to ensure that CJA lawyers and federal defenders will have stable funding and the independence to maintain and improve the quality of indigent defense in the federal courts for many years to come. This afternoon, we're honored to welcome Kathleen Kennedy Townsend as our keynote speaker. The symposium is sponsored today by the Defender Services Office of the Administrative Office of the United States Courts, the Federal Judicial Center, the American Constitution Society, and the Heritage Foundation. I want to thank all of them for their commitment to the Sixth Amendment and for putting on this wonderful event. I hope you enjoy the program, and I will ask the Dean of the University of Baltimore School of Law, Ron Weich, to introduce our keynote speaker. Thank you.
Thank you, Michael. I am very honored to participate in this important event. And it is actually a very appropriate moment that we gather. This is a moment when the criminal justice system in Baltimore, the city where my law school is located, Kathleen Kennedy Townsend City, is under great stress, as you all know from watching the news. Fundamental questions are being asked about fairness, about trust, about the relationship between the police department and the community, and those questions have not yet been fully answered. I've communicated with my students this morning about recent events, and I said to them several things. I said to them that they should work hard on their studies. They should become lawyers, because lawyers are very important participants in discussions in our society about social change and the improvement of justice. But I also said that criminal justice reform is one of the great challenges of our time. It remains so. And so it is very appropriate that we gather to mark one of the most important pieces of bipartisan criminal justice reform legislation in our lifetimes, the Criminal Justice Act. It's also fitting that this conference will be inaugurated by Kathleen Kennedy Townsend. She, as you all know, is the eldest daughter of Robert F. Kennedy, who not only played a key role in the enactment of the Criminal Justice Act, both as Attorney General and later as the junior senator from New York, but Kathleen herself has inherited her father's passion for public service and for social justice, and she's been at the center of many key criminal justice issues, including those we'll talk about today. After graduation from Radcliffe College and the University of New Mexico School of Law, Kathleen practiced law for a time and quickly became engaged in the fight to improve justice in America. I first met her in the early 1990s when I was working for her uncle, Senator Ted Kennedy, and she was working for Janet Reno at the Justice Department as a Deputy Assistant Attorney General in the Office of Justice Programs, where, among other things, she was working to implement a program called the Police Corps, which was designed to strengthen ties between the community and police departments around the country. In 1994, Kathleen was elected Lieutenant Governor of Maryland. She was the first woman, in fact, the only woman to hold that job. She held the job for 8 years. And her portfolio included public safety, where she worked on policing issues and sentencing issues, and had a number of important initiatives to prevent crime and to intervene constructively in the lives of young people in order to stave off individuals from becoming involved in crime. Since leaving her government office, she has remained very involved in public life in lots of ways. She teaches at the Georgetown Public Policy Institute. She's a visiting fellow at the Kennedy School of Government. She chaired Governor O'Malley's task force on retirement security for all Marylanders. She published a book entitled Failing America's Faithful: How Today's Churches Are Mixing God with Politics and Losing Their Way. I recommend that everyone read that. And I know that she will always be involved in the fight for justice in whatever capacity she finds herself in, because she cares about people and she cares deeply about the issues that bring us here today. So please join me in welcoming Kathleen Kennedy Townsend.
Thank you, Ron. And I want to thank each of you for coming out today to discuss this important anniversary. But I also want to thank Ron for his service in the pursuit of justice. My Uncle Teddy was certainly lucky to have you at his side on so many issues with civil and criminal justice and getting people confirmed. Senator Reed was lucky to have you, and as was Eric Holder. And Loretta Lynch would have been lucky, and she might have gotten confirmed before yesterday if she had you around. And I am particularly thrilled that you've chosen to come to Baltimore to be the dean of the law school there, because I think what the law school needs is just your understanding that law is part of the community. It is not separate. You say that in your own remarks, and you make sure that the young people who come to you, and I guess they're so older as well, understand the skills that are involved in being a lawyer and understand how important the law is to making a good city. So we're really lucky to have you in Baltimore, Ron. Thank you. And I want to just say something about Baltimore today, because it is my city and it has been under a lot of duress. Despite the horror that we all saw on the television last night, and it would be hard to miss. I think back of the difference between today and 1968, and I think it's really critical to understand how different it is. In 1968, when the city was torn apart after the death of Martin Luther King, it really produced Spiro Agnew as the law. Remember that? Now I know this audience is old enough to remember that. I was trying to explain that to somebody younger if she had never heard of Spiro Agnew. Blessed her. But, you know, he really came out of a sense that, you know, we need law and order and we need to put people in jail, and that was going to be the answer. And you can see today that that's not the conversation or the discussion that anybody is having. The discussion is we need to reform the police department, we need a sense of justice, we need a sense of due process and transparency. It's a completely different conversation than we had years ago. And we saw today on the streets, not 4 days of burning, I don't think we're going to get that. We saw children and students and parents taking their brooms and cleaning up their neighborhoods because they said, this is our city and we want to keep it our city. We saw people going into that CVS and trying to recreate it. So I think there is anger, there's reason for anger, but there also was, and to say that there's a difference today than there was 40 years ago, a yearning to create something better. And that's why it's so important to have leaders such as you, Ron, at the university, and Judge Blake here, to say we can do better. People want different kind of leadership than they wanted 40 years ago, if we're willing to give it to them. Thanks for letting me get on my soapbox and give you that. I am thrilled. I also want to thank those who have brought you all together. Obviously, you've been thanked already, but everybody loves to be thanked. So, the Defender Services Office of the Federal Courts, I met some of them in the ladies' room. The Federal Judicial Center, the American Constitution Society, and the Heritage Foundation. And then, of course, to each of you. Your institutions might have decided to come, but the fact that you, in your institutions, decided to be here is a tribute to your own commitment and dedication. I have to tell you, I was very touched when Ron called me to ask if I would speak about the Criminal Justice Act. I'm often, as you can imagine, asked to speak about my father's legacy, what he did on poverty or civil rights or South Africa. But this is the first time that I was ever asked to speak about what he did on the criminal justice for the Defender's Office. And I find that too bad. And I think it's part of the problem that we have with the Public Defender's Office is that it doesn't get us enough attention that it deserves. It's not as cool as some of the other areas. And part of our challenge, I would say, 50 years later, is that we've got to make it cool. You can applaud that. I mean, you don't have to, but if you don't believe it, I don't know who is. But that really is the challenge, because if you don't think it's great, people aren't going to be attracted to it, the students aren't going to be attracted to it, it's not going to get the money that it needs, and it's not going to get the attention that it really deserves. So one of the real challenges is to make it really important. One of my father's favorite books was Ralph Ellison's The Invisible Man. And he loved that book, for those of you who read it years ago, because he knew that too often people who are from a different race or a different class are simply invisible. He always made an effort when we went to a restaurant to go into the kitchen afterwards and say thank you to the people who made the food, because he realized usually they weren't thanked. Whenever we went into New York City, we flew into New York City. He was the senator from New York, some of you may remember. We never lived there, but we had an apartment in Midtown Manhattan, but he would never go directly to Manhattan. He would always drive through Harlem, because he said, this is where you need to see that people live here. And I remember when he started a swimming pool in downtown Washington, D.C., and I remember he said, Kathleen, do you want to come with me? And we were driving down in the inner city Washington, and he would point to the kids in the tenement houses, and he said, you know, children just your age live in those houses and those apartments, and they want to swing on the swings just like you do, and they want to do well in school just like you do, and they want to see their parents just like you do. They have the same yearnings that you do. They just don't have the same luck that you do, Kathleen. So remember that. He was always very aware that we were lucky and that others didn't have that luck and were not seen. And I remember once when we were stopped by the police, I think he was doing something that he wasn't supposed to do. I can't remember what. And the policeman didn't realize who he was, and he was screaming at him. He said, then he showed out who he was, and he said, just think if I had been black, what the difference would have been made in that confrontation. So he was always aware that if you are not a certain place, you are really invisible. And he said, the poor are hidden in our society. No one sees them. But he really did make an effort to see them. And as a lawyer, he understood that the injustice can result when poor people charged with crime are denied proper legal representation. And that's why we're here today. When he became Attorney General in 1961, the Criminal Justice Act did not exist. Now, that's not to say that there was no representation for people who were indigent. After 1938, the United States Supreme Court decision in Johnson versus Zerbst said that people should get representation, and most federal courts tried to provide counsel for indigent offenders, but it was really haphazard. They would appoint lawyers who might be in the courtroom at the moment. Those lawyers didn't often get paid. They didn't have the money to do discovery or find expert witnesses, and there were no standards as to whether they did a good job or not. So you might have a warm body, and you were supposed to be happy with it. It meant, really, that people didn't get good representation at all. And those variables made all the difference, as you know, between conviction and acquittal, between fairness and injustice. And that, my father knew, was completely wrong. The scales of justice in this country are seriously weighted against the poor because they are financially unable to obtain an adequate defense. He saw it. He knew it. I mean, he knew what a good defense meant. Some of you may remember that when I was young, my mother was accused of horse theft. Do you remember that? Do you want me to hear that story? You're obviously going to hear it. So we were riding, you know, we lived in Virginia. We were riding our horses, and we were riding near the CIA. They had a lot of land, so that's where we often went. And you wouldn't get stopped in the CIA at that time. And my mother heard these horses whining, and so she stopped, and she saw that they were not being fed. So she got the groom to come and take them to our house. And at that point, Mr. Zemo, who owned the horses, sued my mother. And horse thievery was a hanging offense in Virginia. So this was an interesting situation if you were in third grade, which I was at the time. My father was the Attorney General of the United States, and my mother was accused of horse theft. You were supposed to see both sides of the law. But luckily, my father could afford a good attorney, and he got Lou Oberdorfer, who was head of the civil division, to defend her. She got off. Obviously, he was a good attorney, and he then became a federal district court judge. But he knew that if she wasn't the wife of the Attorney General and had taken 4 horses from a neighbor, it was possible she probably wouldn't have been hung, but she would have been in a lot of trouble. So he was really aware of the difference of who you were and whether you got off or not. And when my father saw a problem, I can guarantee you, he wanted to solve it. He would ask, what can we do about it? Who can help? What results are we going to get? He wanted to accomplish something. He wasn't just interested in complaining. He wanted the facts, the truth, and he wanted to make things happen. And so, In April of '61, that is like 4 months after he became Attorney General, he created the Attorney General's Committee on Poverty and the Administration of the Federal Criminal Justice. He asked Professor Allen from the University of Michigan Law School to be the chair, and he appointed judges, lawyers, and professors from around the country to develop a proposal as to what should be done to ensure that there would be justice for indigent defendants. After 2 years of study, the Allen Committee gave my father the proposed legislation, which basically required every federal district court to establish a system of adequate representation for criminal defendants. Now, I have to tell you, this was not a novel idea. It had been around for quite some time. As early as 1937, the Judicial Conference of the United States had adopted, at the recommendation of the then Attorney General, Homer Cummings, a resolution supporting this very same idea. So it had been around since 1937, but nobody had done anything about it. You can have ideas, right? You all have ideas. But the question is, do you get them done? And that's what really needs to happen. How do you translate an idea into action? It helps if you're the Attorney General and your brother is president. So my father and my uncle really did want to make this happen. And in the State of the Union, on January 14th, President Kennedy said, and he underscored this, the right to competent counsel must be assured to every man accused of a crime in federal court, regardless of the means. And 2 months later, my father sent to Congress the bill that had been recommended by the Allen Committee. And his cover letter detailed just how horrendous it was for poor defendants in this country, how they weren't given the right to counsel, how they were screwed in the criminal justice system, how they often went to prison when they were not guilty, and how it was really unfair. And on March 8th, President Kennedy sent his own message of support to the Congress, saying, this passage of this bill will be a giant stride forward in removing the factor of financial resources from the balance of justice. So you had the President of the United States and the Attorney General of the United States saying, get this bill passed. However, you also had the Congress of the United States. And for some reason, I am not telling you something that should surprise you, they didn't want to spend a penny on poor criminal defendants. As you were just describing, they were afraid that particularly the Southern senators, Democrats though they were, didn't want those guys from Harvard and Yale, dirty-fingered lawyers, coming down and defending African-American people accused of crime in their courts. They just didn't want it. And they weren't going to pass this legislation, despite what the President of the United States or the Attorney General said. So there was an impasse. And luckily, we had a good Supreme Court. And as the first speaker mentioned, they came down that year with the landmark case that we all love, Gideon versus Wingright. I love this story, and you've heard it before, but I'm speaking to the choir, and we can hear it again. In 1961, the same year that my father became Attorney General, a man named Clarence Earl Gideon had been arrested in Panama City, Florida, and was charged with breaking into the Bar Harbor pool hall. Over his objection, Mr. Gideon was forced to represent himself at trial without counsel. He was promptly convicted and sentenced to several years in prison. After his conviction, Mr. Gideon wrote letter after letter to every government agency for which he could find an address, asserting his constitutional right to an attorney. He had almost no thought or no hope of success. But when the United States Supreme Court received his 5-page, penciled, handwritten petition, his efforts came to unexpected fruition. In 1963, the Supreme Court held that the Sixth Amendment to the Constitution entitles all indigent defendants facing serious criminal charges in state and federal courts to a government-appointed defense attorney. And a few months after that decision was announced, my father spoke about Mr. Gideon to the New England Conference on the Defense of Indigent Persons Accused of Crime. He said, "If an obscure Florida convict named Clarence Earl Gideon had not sat down in prison with a pencil and a paper to write a letter to the Supreme Court, and if the Supreme Court had not taken the trouble to look at the merits of that one crude petition among all the bundles of mail it must receive every day, the vast machinery of American law would have gone on functioning undisturbed." But Mr. Gideon did write that letter. The court did look into the case. He was retried, and with the help of competent defense counsel, found not guilty. And he was released from prison after 2 years of punishment for a crime he did not commit. And the whole course of legal history has been changed. So finally, Congress was convinced. Both houses Congress agreed to pass a version of the Allen Bill, and on August 20th, 1964, President Lyndon Johnson signed the Criminal Justice Act into law. Now, as all of you know, it was a pretty pathetic law, right? It was a page and a half, and it basically said, you should do a good job, but they didn't. And under the 1964 Act, indigent defendants facing charges were assured of an appointed attorney, but the bar associations and the legal aid organizations still had to find those attorneys. This might have ended the practice of just appointing somebody at the back of the room, but it did not mean that they were going to find really good attorneys. It did not assure that you're going to get a very good appointed lawyer. And as my father observed, furnishing counsel so that the indigent accused furnishing counsel to the indigent accused will only play lip service to the Constitution if the lawyers aren't competent to perform that service. And no one can legislate professional competence or professional dedication to duty. That comes from people like you in this room who says, we have to make it happen. And after a period of time, it really became clear to people like you and your predecessors that the law had to be changed. By 1967, after my father had been elected to the Senate, the Judiciary Committee recommended significant improvements to the law. And in 1970, my uncle, I know you think this is all about my family, Senator Edward Kennedy co-sponsored amendments to the Criminal Justice Act that created the National Federal Defender Program we know today. The most important of these amendments was the creation of a federal legal service offices structured as either a federal defender office or a nonprofit community defender office. Coverage of the act was also significantly broadened to require provisions of counsel in almost all the criminal justice proceedings, including pretrial, probation, juvenile, and appellate proceedings. Today, the Federal Defender Program is the gold standard of legal representation in our criminal justice system. So we've seen a lot of changes over the last 50 years. We've seen that with persistence, you can change the law. With good Supreme Court, you can change the law. And with people just as you in this room, you can make a law that has been changed, implemented well. So I want to thank you. I want to thank you for coming here today, and I want to thank Ron for saying nice things and allowing me to praise my family. It's kind of a weird thing to do, but I thank you for that. I want to thank each of you for the fact that 200,000 defendants each year receive counsel because of the work that you do. And I want us all to also consider what more could be done to improve the criminal justice system. My work as lieutenant governor taught me that lawyers are really important in this change because we affect all parts of the criminal justice system. Right now, the attention is on the police, and I think that has got to change as well. how police interact with people, how they treat people, how they feel about people. All of that can be done. But it helps if the prosecuting attorneys, if the defense attorneys, and if the judges hold the police to a certain standard and help them reach the standard. This has not have to be a punishment system, but a helping system in which we all work together. Because what we really want to do is not just punish crime, but prevent crime. And if we do that, we will live in a much better world, a better United States, and a United States that really is dedicated to justice for all. Thank you very much.